Thank you. Under new business, let me jump ahead 1 minute here. Delegation agreement update. This is just information item. The last PZA committee, the committee voted to move ahead with a reapplication for the delegation agreement. In discussion with the state's attorney's office, the decision was made to let's just proceed with the grant application, get it submitted under the terms that the EPA is asking us to comply with. And once we've got that completed and have final agreement with the EPA, we'll come back to the full board with a completed application. Mrs. Bernard.
Thank you, Mr. Chairman. So when do we expect it to come back to the full board?
Well, once with the grant, the timeline on the grant application is the 1st of March for a first initial application. Within a month or two would be a final submittal.
Okay, and how much are we requesting?
We haven't determined that yet. PZA kind of said more, but we're not clear exactly how much. Whatever we request in a grant, of course, would have to be spent, so it has to be a real.
Right. One thing too I wanted to point out, just to correct some incorrect information that was given to us last month. I have a copy of the actual portion of the Environmental Protection Act 4415 ILCS 5/42. And it does say here, as far as with administrative citations, it says that penalties shall be made payable to the Environmental Protection Trust Fund to be used in accordance with the provisions of the Environmental Protection Trust Fund, except that if a unit of local government issued the administrative citation, 50% of the civil penalty shall be payable to the unit of local government. The delegation agreement that we have from 06-07 had given the county authority to do citations, so I just wanted to let my fellow board members know that this may not necessarily cost the county as much as it seems, because an aggressive and a competent local inspector that does issue citations, it's a win-win in many ways. Number one, the county does get some of the funds. And number two, it's like stopping speeders before they have a fatal accident. It's kind of almost like a prevention measure. So there's other benefits to it that, you know, will help pay it off. So I just wanted to let the board know, so we don't think, you know, consider that there's all negatives with it. Thank you.
Okay. Any questions on the delegation agreement? Landfill litigation. Brief discussion last month as to status, and several board members requested that Mr. Helsten join us today and give us an update and ask for some direction. So, Mr. Helsten, if you could join us up here. I furnished an email to board members. I hope you all received that. If you did not, I've got a few extra copies up here. Yesterday, Mr. Tripp, did you? This email was a memo provided by Mr. Helsten's firm, just trying to outline the status and the history of the Town and Country matter, both in narrative form and a chronological order summary of dates. So I hope you've all had a chance to review that briefly and prepared with some questions. So, Chuck, thanks for making the trip in some bad conditions last.
No problem. In summary, good morning, board members. It's been a while since I've seen you. In summary, Town and Country number 2 has gone this way. The City Council approved the second application. The Pollution Control Board affirmed the City Council's decision. We appealed to the 3rd Appellate District on a number of grounds, 6 or 7 grounds. The 3rd Appellate District reversed the Pollution Control Board and the City Council and agreed with the county the first time around, saying the 2 sites were substantially similar. There is a provision in the citing statute that says if a subsequent application is substantially similar to the first one, they cannot be filed, the second application cannot be filed within 2 years. That was the basis upon which the 3rd District sided with the county. It did not, of course, address the other issues, which an appellate court never does. It determines what it needs to do to dispose of the case and disposes of the case. Immediately thereafter, within 30 days, Town and Country filed a motion to reconsider, saying, no, they're not substantially similar. They are different in these respects, and also the county won Town and Country number 1. They pointed to us and said, the county won Town and Country number 1 at the Supreme Court level and established the law going forward in the state, which is that you focus on the decision of the Pollution Control Board on technical issues. And if there's any evidence to support that, we call it manifest weight. You would think manifest weight would be quite a bit, but really the legal standard for manifest weight is some evidence to support it. Town and Country's attorneys said, look, the county in Town and Country 1 established the law. So now we all have to live with the law going forward in this state. And there is some evidence to support the fact that these applications are not substantially similar. 18 months later, the 3rd Appellate District said, yes, we agree that they are not substantially similar. Here was the only problem. The Pollution Control Board did not address the issue of substantially similar in their opinion. So we were in front of you, I believe it was last April, asking you for authority to request a supervisory order before the Supreme Court, because the 3rd Appellate District, on 2 grounds. Number 1, they had found that they were upholding the Pollution Control Board's determination that they were substantially similar, when in fact the Pollution Control Board never made that determination. Number 2, they did not address the other 5 or 6 issues which the county had raised when they held in favor of Town and Country on the rehearing. You voted, I forget what it was, 24-2, 23-2, whatever it was, to pursue a supervisory order from the Supreme Court. The supervisory order was promptly granted by the Supreme Court. So again, they sided with the county, saying, yes, there are problems with the 3rd District's ruling. They remanded it to the 3rd District with instructions. The 3rd District then, on October 8th, issued their opinion. The gist of the opinion was they discussed the substantially similar issue and said, no, they're not substantially similar. The Supreme Court told us, discuss the substantially similar issue, they're not substantially similar. We've also been told by the Supreme Court to address the other issues which the county raised, and they did it in what they called a summary order, which means we did, it doesn't. We did, it doesn't. We did, it doesn't. Each of the other grounds were decided by the 3rd Appellate District in that fashion. Now, I heard some of the colloquy this morning and the back and forth about what Mr. Boyd had said, and I think what Mr. Boyd, I wasn't here and I haven't reviewed the tape, I think in fairness to Mr. Boyd, what he was probably saying is that decision from the 3rd Appellate District, because it is rather terse, in short, indicates that they're probably not happy with the county seeking the supervisory order from the Supreme Court, and the Supreme Court granting it, saying we're supervising you. I think that's right. You know, that's the way it is. I think that is right. What we have done since then is prepare, if you want to file it, a petition for leave to appeal, just like we did in Town and Country number 1. That's the first case that we won, to the Supreme Court. The Supreme Court has told us that that must be filed by January 23rd. So it is substantially ready. It must be ready. There's no way we could do one in the next week or 10 days, because you need to frame the arguments in a way that you feel the Supreme Court will take the case. So that is ready to go. The issue is, do you want to file it and go forward with the petition for leave to appeal. That in essence is the issue.
One of the portions of the Supreme Court's decision in Town and Country 1, when it got to the final stage, was a ruling on the fact that, in their opinion, health, safety, and welfare were not protected in that application. One of the comments we hear now, and I think it's an interesting question, is what's different between application 1 and application 2 in terms of protecting the health, safety, and welfare of the community?
Good question. Good question.
Is anything different?
Here's the way to. There's not a simple answer, but there is a fairly short answer. In Town and Country number 1, the Pollution Control Board, when they sided with the county, what we had said is there has not been sufficient characterization of the fractured bedrock. In other words, the fractured bedrock that lays below the aquifer in which the landfill will be situated. This is a landfill that will be situated in an aquifer. Okay? That happens. That is not necessary. And I want to be fair to both sides here. That is not necessarily a bad thing if you have created an inward gradient where you have the pressure of the aquifer pushing on the sides of the liner. That's not a bad thing if it's done properly. And if you have a sufficient natural in situ layer underneath to guarantee or at least serve as a backup, so if there is diffusion through the bottom of the landfill liner, it doesn't migrate either horizontally, but more importantly vertically downward through the fractured bedrock into a drinking water aquifer. This is a drinking water aquifer. There's no question about that. The Illinois Supreme Court found this is a aquifer used by a number of people. Mr. Chairman, what the Pollution Control Board said the first time is, we find that criterion 2, criterion 2 says that you must demonstrate that the proposed facility is designed and located so as to protect the human health, welfare, and the environment. They said, we agree with the county that one vertical boring, only one for a site of this size, is not sufficient to show that there are no fractures that would go into the deeper aquifer. That's not enough testing, okay? The second time around, on the second application, the engineers for Town and Country did several more, but we hired Patrick Engineering, an outside consulting firm that doesn't do work for any applicants. That's the reason we hired them. We didn't want the accusation that, well, they're riding a horse, as my dad used to say. My dad used to say, everybody's riding a horse, you just have to figure out what color the horse is that they're riding. Patrick Engineering, we thought, was uniquely qualified because for 18 years they have been the contract oversight supervisor for IEPA. So they don't favor Waste Management or Allied or anyone else. They're not, there can be no accusation that they are testifying against Town and Country because they do work for Allied or Republic or Waste Management or Group Industries or whomever. Patrick, the second time around, said these still aren't enough borings. They're not representative. They did not address the issue raised by the Pollution Control Board in number 1. That's one of the issues that we would take up here. So Town and Country would say what is different is we have done additional borings. The Pollution Control Board the second time around found that the additional borings were sufficient to characterize the potential downward vertical migration of contaminants. And we've also obtained our permit from IEPA after 2 tries. Again, the county reviewed the permit, objected to it twice. EPA denied it, saying, yeah, they issued a number of denial points, but they did. Town and Country eventually, on the, I believe, the 3rd try, did get their permit. That's what Town and Country would say. It is different. We would say, no, it isn't different, because really, you have to do more what we call diagonal borings to make sure you cut across a significant portion of the site. If you just do downward vertical, all you're determining is that there is no vertical fractures in that one location. But that does that answer.
Yes. Board members, questions? Mr. McBride.
So what you're telling us is that the same problem that existed from the start is the same problem that exists now?
That's what Patrick Engineering has said, has told the county that not that this can't be designed safely, not that ultimately it can't meet criterion 2. I want to be clear on that. I want to be fair to everybody involved. Patrick Engineering and the county has said there still hasn't been the deficiency noted by the Pollution Control Board in number 1 and affirmed by the Illinois Supreme Court, recognized by the Illinois Supreme Court in number 1, has not still been addressed, sufficiently addressed. That's Ms. McBride.
So the problem is still there.
The testing problem is still there. Our whole position is we don't know if there are enough fractures to pose a danger, that the lack of testing problem is still there. That's our position.
Can they be required to test again, test the way that you said?
They would say you could do that as part of a settlement agreement if you reach one with the city and Town and Country. Town and Country would say, if I was on their side, what I would say, if I was advocating for them, I'd say, I got a permit from EPA. I don't need to do any more. They thought that was enough.
Will Town and Country guarantee us that this will not happen, and if it does happen, they will be responsible for the first $100,000 to repair it?
100,000 won't come.
100 million, 100. First 10, 15 million to repair.
Yeah, for 100 grand, they make that agreement.
That's a good question, Ms. McBride. They already have to, under the law, if there is a release from the landfill, they are already required to post, before they ever start developing and operating, they must file sufficient closure, post-closure, financial assurance, and operating assurance. They will have to, as we say, chase the plume of contamination if it leaves the bottom of the line, or the problem is that then the horse is sort of out of the gate. To answer your question directly, could you require them? You could in a settlement agreement. If you reached a settlement with them, what you could do is, as I've said before, and there are many members of this board that have been here through the entire tenure, my sympathies to you. As I've said to many of you before, the safety issue is this gentleman's determination. There's a case involving Jim Glasgow, the state's attorney in Will County that I work for, that went up the appellate ladder, and the appellate court said the state's attorney of the county is the chief law enforcement officer. He determines whether or not the health, safety, and welfare of the public has been assured. So it would be Mr. Boyd's determination as to what more needed to be done. He could consult with Patrick, say, what more would you like to see? The issue of whether you want a second landfill, which is consistency with your plan, another issue which you have raised because your plan only calls for one landfill, is a legislative decision, as we've talked about. That's one for you to, it's a policy decision for you to determine.
Well, I'd like to just ask a question for my information. Isn't there another landfill already out there somewhere?
There is the waste management landfill, which is now shut down. This is the landfill that I believe started operation in 1971 or 1972, ceased taking waste in the late 90s, and they filed 2 applications for expansion. The first application was reversed by the 3rd Appellate District on the notice issue. The first one was approved by this board, but reversed by the 3rd District on the notice issue. In other words, sufficient notice wasn't given to adjoining property owners that are required to receive notice. The second one was denied by this county board. We're defending you on appeal. Last week, Waste Management filed their their opening brief before the 3rd District.
If they didn't allow this other one to continue, why would they allow another one to start?
Build up.
Different issues involved with each of them. They have different facts, different issues, 2 different locations, 2 different sets of hydrogeology as well.
You touched on a couple of the points that you think would be possible to raise in your leave for appeal.
Yes. I don't, and I have to get guidance from Mr. Voigt here. I commend Mr. Voigt's policy and the county board's policy of doing this to the greatest extent possible in a public session, but there are some things I just don't want to talk about, which are strategy considerations, because you tell the other side where you're going. But the issues that could be raised are, first of all, the first issue, and it's in the memo, would be a summary order by the 3rd Appellate District was inappropriate for a case of this importance, a case that's already gone to the Supreme Court once, that we won, and the second time around, the Supreme Court granted a motion for supervisory order. If they did that, it's an important case to the Supreme Court. So the ruling by the 3rd Appellate District, where they say in one sentence, we looked at it, we did, it passes, is not an appropriate discussion and review of the merits of each of those positions. That's the first thing we would say, that there should have been a detailed, thorough discussion of each of the issues which the county raised. The second issue is the plan consistency issue. I heard some comments before about technicalities. I don't consider plan consistency to be a technicality because it's your policy. It's the policy that you promulgated, your planning policy, your countywide planning policy. Your plan calls for 1 landfill, not 2 landfills, only an expansion of a contiguous these expansion must be contiguous to the existing landfill. I assume what you were trying to do was limit impacts. You were trying to limit impacts. The next issue is the notice issue, which Ms. McBride, that is what was Waste Management's Achilles heel the first time around. There is a notice issue here too. I feel the notice issue here is as egregious as the one that Waste Management had, if not more. I do not consider that to be a technicality. I don't consider notice to affected property owners to be a technicality, nor does the legislature, since the legislature said notice is jurisdictional. If you don't give notice, it can be raised for the first time on appeal, and the application is void. So that is a substantial issue. Those issues are what we call legal issues, where the Supreme Court, all you do is argue the law. You don't have to argue the facts. The Supreme Court reviews those de novo. That's important for this reason. De novo means they give no weight or deference to the 3rd Appellate District's decision or the Pollution Control Board's decision. They look, de novo is anew. They look at it anew. The other issues which we could raise are fundamental fairness issues. We don't need to get into all of the fundamental fairness issues. The other issue, Ms. McBride, would be the one you raised, that the deficiency in the testing and characterization of the site, which the Pollution Control Board and the Supreme Court recognized the first time around, has not been addressed, and for that reason, criterion 2 was not met. Substantially similar would be the other issue. Are these in fact substantially similar? Remembering again the 2-year prohibition. So those would be the grounds that would be raised. As far as cost, I've heard cost the first time around, and I was asked by the state's attorney and the chairman what can you do on cost if we elect to go forward, not saying we go forward. I looked at the cost the first time around. The cost the first time around on appeal was $125,000. I went to, that's substantially my appellate department's cost. I went to my appellate department that bills at $295 an hour for government matters and representing units of government. So what can you do? What can we just essentially break even? They said, we can at $240 an hour, which would, and we could give a not to exceed of $79,000, that no matter what, you would spend no more than $79,000 because the county has, and Hinshaw have a long-standing relationship. That would be the maximum. The issue of the de novo issues are important because $79,000 is if we have to look at all facts, if some of the issues are factual, because if you have mixed questions of fact and law, you have to look at the entire record and brief accordingly. The record in this case is 10 to 12,000 pages, as it was the first time around. We don't know if the Supreme Court will accept the petition for leave. They could accept the petition for leave or deny it after we file it. If we file it on January 23rd, I would imagine you, as I indicated, you would hear sometime between March and May whether or not they would accept it. If they accept it, they don't need to accept it on all grounds. They could accept it just if we raise 5 grounds, they could accept it on 1, 2, 3, 4, or all 5 grounds. If they accept it only on legal issues, then all we're doing is briefing the law, and your cost would be about $24,000 is all. Where you run into the cost is when you have to research the record on factual and scientific and technical issues, because you'd be surprised when you review the records. We were when we went to the Supreme Court the first time. You'd be surprised what you find the first, second, and third time that you read the record, that the second, third time that you did not see the first time around that supports your case. Any other?
Trip?
You recommend that we go into executive session? You had comments to make?
No.
No.
All right.
Unless you want to discuss strategy, but I don't think that's our role to advise on strategy. Mr. James?
Thank you, Mr. Chairman. Helsten, good to see you again.
James, good to see you.
Question, you'd mentioned something about the waste management. So we are involved in a lawsuit yet at this time with waste management over and above this lawsuit?
Over and above this one, but again, any cost incurred in defense of waste management's lawsuit, they reimburse the county for. That's what we wrote into the host agreement when we started 8 years ago, because I did not want the taxpayer to be out of pocket for any money, any effort incurred by the county in defending it. So waste management, when reimburses the county, in other words, they pay us for fighting them each step of the way. They paid. They reimbursed the county on Town and Country number 1 because they said, we will reimburse you for defense of your plan. This is an assault on your plan. Partway through number 2, they determined they didn't want to do any more reimbursing.
Thank you, that's what I wanted to take away.
Sounds like a full employment clause for attorneys. Mr. Enns?
Yeah, I wonder if you could maybe clarify a little more on something Sherry asked. You said that they do have enough monies for any litigation down the road? Is that
They have to post financial assurance for closure, post-closure problems, and in the interim, the Act, Section 22 of the Environmental Protection Act says they must be responsible for any problems that arise during the operating history as well, and 30 years thereafter, after closure.
all right? And then a follow-up on that. What if they file bankruptcy? Who's stuck with this bill?
During the operating life of the landfill, that's a good question. The closure, post-closure financial assurance that they have to post could probably be used for a portion of that, because you would be going through premature closure. So what IEPA would do is trigger the bonds or whatever, the performance bonds, the payment bonds, the letter of credit. They would trigger that. Whether that estimate covers all costs is another issue.
Do you know what they require them to put up this bond?
It varies landfill by landfill. What happens? Let me explain, Mr. Spence, the procedure. It's every 2 years, biannually, you must update your estimate. The operator and owners, consultants or engineers submit the cost, the revised cost every 2 years. EPA's engineers look at it and either approve it or disapprove it, and they negotiate a figure. It is intended to cover closure, post-closure cost contingencies, and it does have some, there is some padding in there for response remedial actions, but it is not primarily directed toward that issue. So the issue you raise is a good one. Well, what if 8 years into a 25-year or 20-year operating life, a company goes bankrupt? That's a good issue.
Mr. Scholl?
Thank you, Mr. Chairman. Considering the background of the case and the attitude of the courts towards our position taken, is there still adequate maneuverability issues to pursue preventing this landfill?
I think you have some good issues. I could never guarantee, number one, that the Supreme Court is going to take the PLA. I would never presume that. Even if they take it, I cannot presume that you would win, although if they take it, that's an indication that they're interested, as they did the first time around Town and Country number 1. It's a good indication that they're interested in the case. This is a case of interest to them because they decided it, made new law the first time around, and they did grant our motion for supervisory order last May. So, but I cannot guarantee. You have some good issues. In my opinion, again, with bearing in mind your state's attorney's admonition to not discuss strategy, I think the de novo issues are strong issues. Plan consistency and notice. The other issues are good issues as well. It's just they involve mixed questions of fact and law, which are a little more complex, a little trickier. They're not as straightforward.
Yes, Matt, then basically what you are after here is a determination by the board that if to authorize you to continue or to halt litigation at this point. Is that correct?
Well, I was asked to come down. Here. We prepared the PLA consistent with the board's direction last April when they said pursue the motion for supervisory order and keep going. I was asked to come down here to answer questions as to whether, and then you would make the determination as to whether you want to file the petition for leave, which is ready to go on January 20th.
I guess it was the board's initiative to bring up the point, do we continue or don't we? Because the event that we're discussing was the Appellate Court decision. I think it's responsible at any point in litigation to evaluate where you are, what the likelihood of success is.
My personal opinion on this, and that's not worth much, but
it is. You're an elected official.
is that, you know, I can understand where organized labor is coming from. I can understand where business is coming from because their job is to maximize profit, minimize loss. You know, and I can understand where the city's coming from. But bottom line to me is the impact that this will have on our water. We're well people, and it's going to have a tremendous impact. Therefore, what I would suggest and what I would urge board members to do is to authorize the legal counsel to pursue this, take it as far as we possibly can. I know there's a monetary issue that we have to be cognizant of, But we've got to protect the future is my position.
All right.
Is that a motion?
Is that a motion, Mr.?
Yes, it is.
Is there a second to that motion? Mr. Tripp with a second. Mr. Stauffenberg had a comment.
I just have one question, Mr. Helsten. We were told that possibly the Supreme Court, if would deny this, could send it back to the EPA.
No, here's what they could do. That's a very interesting point. Since not the EPA, the Pollution Control Board, since in Town and Country number 1, the Supreme Court said the Pollution Control Board is the agency from which, that's the decision from which an appeal is taken. Before that, we didn't know in the state, believe it or not, 30-some years of the citing statute, we didn't know whether the final decision under 40.1, the appeal provision of the Act, was from the City Council in this situation, the City Council's decision, or the Pollution Control Board. So that was the issue before the Supreme Court. They said, well, we're going to tell you what it is. It's the Pollution Control Board. And we're also going to make some more law. We're also going to say that the Pollution Control Board, since it's a specialized body of, it must have a geologist and engineer by Section 5, which Mr. Bernard was talking about before the Act. That section of the Act says it must be composed of certain people with specialized scientific and technical expertise. The Supreme Court said every technical scientific issue should be determined by the Pollution Control Board. So what the Supreme Court could do here is accept the PLA, hear arguments on the substantially similar issue. Remember, that's never been decided by the Pollution Control Board, and say, we'll hold the other 6 issues or 5 issues, remand it to the Pollution Control Board, see what they do with that one, and then determine what we do with the other one. I think that's probably what was.
Well, my question then was, because there is a new chairman there, are chances better? From the allegations that we heard this morning?
I'm surprised every day, and I've been doing this for 30 years, I'm surprised every day for the last 30 years, both pleasantly and unpleasantly, at decisions I get out of state boards and state agencies. So I really don't know.
Okay, thank you.
Mr. Whitten.
Number 10. Thank you, Chairman. Good morning, Mr. Helsten.
Good morning, Mr. Whitten.
I'm Leo Whitten, District 23. Is my hair party good enough for you? All right.
Leo, address the chair.
All right. What I want to say is, if we're worried about pollution, Waste Management has been on Route 49 for over 25 years, and they started with outliners. We're not doing anything about that. We're not doing one thing about what is leaking out of Waste Management right now. But we're losing jobs. We was elected by the people, for the people, and we should not fight the city. If the city wants a landfill, we should go with the city. Thank you.
Just one, Mr. Whitten, just one response. There is corrective action being taken at the Waste Management one, simply because they have to by law, which was my answer to Mr. N's question over here. They have to, and EPA is requiring them to, because it was, as you said, there were no lined landfills in the early 70s when they first started. And that's where the problem is in the unlined landfill.
Mrs. Schmidt.
Thank you, Mr. Chairman. I just want to say, with Mark Walkett, my husband Tim and I took a trip to Lake County, Indiana, and all you know that I've been trying to get them here to talk to you, and they've had some difficulties with illness and things like that. February 9th, they will be here. And like Mark said, this is a new way, it's a new day, and there's a new way to take care of our garbage other than landfilling it, and we need to take advantage of that. There's still jobs, probably more jobs than a landfill. It doesn't pollute, turns 70 to 90% of the garbage into ethanol, and we can't do better than that. Pays host fees. $17.25 tipping fees as opposed to $41. It's a win-win for everybody. And it's something we should be pursuing, and we will be pursuing. The days of landfills hopefully are over, and we can get past them and find a new way to take care of our garbage. It's archaic, and it's time we found something new, and I think they have found it. So this county has dodged a bullet for all its life and never had a huge landfill, a huge stinking pile of garbage in the middle of their county. They've avoided it. Pontiac is known to be the second largest, landfill in the United States. We could have been that municipality or that county, and thank God we didn't do that. But we, right here and now, can stop that and not be that way, and bring alternative energy and alternative ways of dealing with things into this new century here through Kankakee County.
Can I ask, Mr. Helsten, do you have any experience in alternative technologies, either in the siting process or in consulting with any governmental body?
I have in consulting. I think eventually they will be perfected. I think the waste companies eventually would want to go that way, because landfills are a very capital labor intensive proposition. I think Adam Smith's invisible hand is alive and well today as it was in 1760, that industry will continue to look for cleaner, quicker, better, more cost-efficient ways to do things. The procedure which you talked about is a proven technology with one caveat: on a limited volume scale. That's the problem. The issue that we face is, for how much longer are we going to need landfilling before alternative technologies become they're perfected as far as the treatment. The issue is, when can they take a commercially reasonable amount of volume? That is because the city of Chicago generates, I would assume this facility probably has a throughput of 1,500 to 2,000 tons a day. Is that correct? That's about max in the technology right now. To put it in perspective, I think the last figure from the Chicago metro area is, per day, I think the Chicago metro area generates in excess of 50,000 tons of waste a day. So therein lies the rub. I think if you went to the primary waste management companies like Waste Management, Veolia, Republic, now that they've merged Allied in, said, are you working on alternative technologies, and are you working very rapidly on alternative technologies? I think they're saying, yes, we are. Again, because eventually, at the end of the day, they are the better alternative. There's no question about that. The state and the Solid Waste Planning and Recycling Act has a hierarchy of waste disposal preferences. The state has determined which are most desirable and least desirable, and of course, landfilling is at the bottom. It simply is, but it is what we have now. It is the commercially reasonable method of doing it. Also, the landfill of today, to go to Mr. Witten's issue, the landfill of today with double liner systems, leak detection devices, everything else is so much different than the landfill of the 50s, 60s, and 70s. It would be like comparing an Edsel or a Nash to a Lexus at this point in time. There's no comparison in the safeguards that are now implemented. Yeah, thank you.
Hands are up. Mrs. Bernard.
George first.
No, I'll pass. Let them go first.
Oh, George.
Elder statesman.
Hi, Joe.
Hi.
You mentioned that there are some members here that have sat through the whole process, and I'm one of those.
Yes. Yeah.
When I entered into the first hearings and the consequential discussions and so on, I had an open mind as to what could and couldn't take place. And I absorbed as much as I possibly could, which probably wasn't a whole lot, but it was information that I didn't have previously.
It was, and I may say, when you were head of the RPC, you served with distinction and honor. You were very conscientious.
Thank you. What I wish to say now is we have sufficient evidence as presented by you to continue this fight because we have no alternative. We need to maintain the evidence that has been presented to at least give the community the understanding that we are not ready to lay down and let this thing happen. It's evident to me that we have dealt with a lot of factors that we did not have control of. And if those factors have changed, if the Supreme Court is willing to take the case again, I believe we have a better than excellent chance of succeeding. And therefore, I fully support maintaining this suit.
All right.
Mr. Vickery?
Thank you, Mr. Chairman. I would just want to address some of the economic issues here. I asked Mr. McCarty to give me a rundown of our total general fund budget for the last 5-6 years. It amounts to about $175 million. So the expenses here have been about 0.75% of the general fund budget over the last 6 years. We have in the budget on 09 necessary funds to continue this fight. I only bring that up so that members who are concerned about that economic issue can rest assured that we have included that in the 09 budget. The next thing, it seems that many of our constituents who know that it's going to cost money are willing to pay that. So they understand that continuing this case costs money. And I haven't talked to any constituents in my district who want me to not do anything but move forward. So if they're willing to pay, it's their money. And I only affirm their wishes. So with that, I just want to say that $1 million, we throw these $1 million numbers around or whatever it is, but it's a very small percentage of the general fund budget that we have expended over the last 6 years. And thank you, Mr. Chairman.
Mrs. Bernard.
Thanks, Mr. Chairman. Good morning, Mr. Helsten. Just a couple of things I wanted to mention too. There were concerns brought up that this is about taxes and jobs. Landfills are obsolete, they're archaic, as was mentioned. And the thing is that the trend in this nation, not just here locally, is to start thinking green, the creation of green jobs, sustainable jobs. It's part of President-elect Obama's stimulus plan. There's going to be a focus on green jobs. So I think what we need to look at is instead of thinking that we're closing the door on jobs or cutting back jobs because we're not going to, if we continue the fight, I think continuing the fight is the best thing we can do, because if this landfill were to come to fruition, I think eventually we would be actually sowing the seeds of our destruction of this area in the long term. Because once that river is polluted, the river is the economic engine. So I just think the best thing we could do is continue the fight. And also, Mr. Helsten brought up about the possibility of plumes, of pollution. We've got a couple of those situations in the county right now. I believe it's Mundy Brothers out in Pembroke. I think it's considered a Superfund site. I don't know if it's been cleaned up yet. There's also the limestone, the shell oil spill. So why take the chance of doing more, especially since there are alternatives? And just one last consideration, the new alternatives that are out there, they are limited in scale. And actually, I think that's a good thing. Because I think them being limited in scale means we can handle our stuff, and the city of Chicago needs to learn to maybe put several smaller plants throughout the city instead of letting us become the dumping ground.
One response, Mr. Bernard. Landfills are still necessary, in my opinion, until alternative technology becomes such that it can handle the volume in a commercially reasonable manner. Is that 10 years? Is that 12? Is that 13? Is that 15? We don't know.
Mr. Chairman, if I may respond to Mr. Helsten quickly. And I understand what you're bringing up, Mr. Helsten. However, I think Chicago right now has a far more pressing need. I think that these alternatives would work in Kankakee County. And Chicago, they're generating 50,000 tons a day.
Chicagoland area.
Chicagoland area.
Yeah,
and they need to get more aggressive in finding solutions instead of just looking to the Southland for a convenient dumping ground.
Yes, thank you, Mr. Chairman. I just got 2 points of clarification very quickly. The term invisible hand was used, and due to the climate in Illinois, I think we need clarification on that, especially for the press. We're talking about not selfish interest, but the pursuit of self-interest. And the second point is with respect to the dump. The city, I am totally opposed to the city dump concept. It's a county landfill that is issued. It's a county policy, not for the city to have a landfill.
Absolutely. Invisible hand, Adam Smith said, best product or service at lowest price delivered the quickest will control the marketplace. He was right in 1760, and I think he's right today.
Call the question.
Mr. McLaren has a question.
Thank you, Mr. Chairman. I do have a couple of questions here. Mr. Helsten, if you don't mind, if I can address Mr. Helsten, Mr. Chairman. Did I hear you correctly saying that if the Supreme Court rules in favor of our PLA, that cost will not exceed $79,000?
Yes, $79,000.
Very good. And if we are successful at the Supreme Court level,
yes.
And I'll try not to ask you anything about strategy or anything on either side, and if I do cross that, please, what kind of options does Town and Country have if we are successful?
That's it.
That's it, completely. They would have to refile another petition.
They'd have to refile another application.
Application, thank you.
The Supreme Court is the court of the highest determination.
Very good.
And last resort.
And I guess on the reverse side, if we were unsuccessful?
If you're unsuccessful, then they have a permit. They have a permit. That
The county has no other recourse?
You could, again, that's getting into strategy.
That's what I was afraid of.
Certain issues under Section 42 of the Act, 45 of the Act, but again, it's getting into strategy.
Okay. And I just want to say, I did come here today with the thought process of not spending any more money. I had some wonderful phone calls from some people that wanted us to continue this fight. I've also talked to many of my constituents too, and they were tired of spending the money. But what I've heard here today, and it's not been from the public commentary, it's been from what's come from the panel up front here. I think I've changed my mind. With the dollar amounts that are out here, I think it is minimal compared to where we have been. And my only concerns is if we are unsuccessful, what our options are going to be and how long we would continue to do anything else as far as spending money after the Supreme Court level.
That's a tougher fight. And look, being candid here, some of your colleagues here raised the issue: could we settle? Could we settle with Town and Country? Could we try to negotiate this? Yes, you could, as long as there is as long as there's uncertainty. Either the Supreme Court has not denied our petition for leave, or if they accept it, they have not denied our position after we after we argued. It is, Mr. McLaren, this is an all or nothing essentially. If it goes to the Supreme Court, one side's going to win, it's going to be an all or nothing proposition. If you were going to attempt to settle and get concessions that you thought were necessary to protect the human health and the environment and provide economic benefits, there's always more certainty in a settlement that there is in litigation, as I've told you before. All I can tell you, someone asked me here a few years ago, what can you tell me for certain going forward? That a lot of money is going to be spent on both sides. That's the only thing I can tell you for certain. And if our petition for leave is accepted and we go forward, then one side will win. It'll be 100% proposition. Either Town and Country will win or the county will win. It's an all or nothing proposition.
Could I jump in first?
Yeah.
What types of things could be part of a concession or a settlement agreement?
Well, you have to.
We have to ask that question.
Hypothetically, the first issue is the safety issue. You'd have to go back and to whatever consultant you wanted and say what further characterization would need to be done for this to satisfy number 2. You could say that has to be at Town and Country's expense, and then the issue becomes: do you share any portion of the benefits, the host benefits, going forward? Do you have any other safety steps you want under your plan that would be implemented as part of the settlement?
Okay, Mr. Legess hasn't had a chance.
I was under the impression at our last meeting that we were told you couldn't raise new issues. You could only argue the point that the appellate court rejected. You're saying that we can now argue?
No, that we argue those issues. What they rejected, they did in summary fashion. What we're saying is we would go to the Supreme Court and say a 2-sentence determination on each of those was not sufficient. We would raise all of them that were. Okay.
The other question I had was, can the city of Kankakee, can the city council, can they vote to withdraw their citing petition right now? Would that end it? Or is it too late for that?
I think it's too late. I believe it would be too late because their decision is a final decision under 39.2D, I believe. Theirs is a final decision that cannot be withdrawn at this point.
Anybody else? Mr. Enns?
5. Yeah, I have one more question. Probably not a legal question, but my understanding is you represented different governments, landfill issues. In the state of Illinois, is there any other landfill that's based on this reverse gradient?
Inverse gradient? I believe in part the Envirotech one in Morris's. I believe in part. I believe in part the Lee County landfill, the expansion by Allied is. I believe those two. I may be wrong, but I believe that those two are inward gradient facilities. I'm trying to remember. In my home county, I'm trying to remember if the Winnebago Reclamation Facility, if their new north expansion is an inward gradient. I'm not sure if it's an inward gradient. There are some.
Okay. Hasn't Lee County had some leakage there? Or are you not aware of it?
That would Lee County. That would be the old. Here's the chronology of Lee County. The Lee County landfill was first the Dixon Municipal 1 and 2 landfill. Those were run by Dixon back in the days before we had stringent regulations that turned meant intense, capital-intensive, investment. It would go to Mr. Whitten's point. It would be like the old waste management landfill of the late 60s, early 70s. Those were unlined landfills. And Dixon 1 and 2, then they said, we have to do something, we got to get out of the landfill business. At that point in time, I believe they contracted with Allied. And Allied said, if you give us the expansion, we will address, then it became the Lee County landfill, because it was in, while units 1 and 2, Mr. Enns, were in the city of Dixon, any expansion was going to be in the county. Dixon wasn't going to, been there, done that. They weren't going to annex any more land and be the siting authority. So what Allied said is, we will address that issue if you give us the expansion. The other problem with that site, it's a perfect site for a landfill because it's next door to the old Green River Army Arsenal, which is a Superfund site that was being remediated too. So you could take a comprehensive approach to all regional groundwater problems that existed in the entire area.
Need to take pit stop here again.
Is 3 taper?
It's a 3 taper.
Higher capacity.
Start writing down my hand. Late for work. It's a long story.
These jibble cars are still out there.
Don't worry about it. He went to lunch.
Good? Mr. Clark?
I think that, the majority of our constituents and from what sounds like the majority of board members already know kind of the way that we want to proceed with this issue. It's been excellent having Mr. Helsten here to, be explained on, further informed on the status of the litigation and everything. I'd just like to say that, if we do file this brief with the Supreme Court and it is upheld, one of my concerns before was that the citing process would just start all over again. However, I think that with the upcoming change in administration on the city level come this April, that hopefully that we won't have to deal with this again. So I would just like to call the question and let's tell everyone exactly how we feel about this. Let's make our vote heard and let's go ahead. And I think it sounds like the board wants to proceed with this litigation. So.
Any other comments? Mrs. McBride?
Yeah, this is just a comment. When the landfill gets so full, it goes up, right? Starts going up in the air. So if you go down I-94 to Chicago and see that landfill on the east side of the highway where it started down, and it now looks like mountains, like the Rocky Mountains over there. Thank you.
Mr. Vickery.
Thank you once again, Mr. Chairman. I wouldn't have brought all these germs today, but I thought it was important that I listen to Mr. Helsten and infect my friends here. So, I thought it was really important meetings. I thought I had to come. I think several issues that came up today only reinforce the importance of the delegation agreement. And I hope that we can move forward on this delegation agreement because off in the future, and as we need it now, but in the future, this delegation agreement is a very important thing. Thank you.
Question.
Sounds like a ready to vote. Roll call vote, please. The question before the board is to proceed with. Well, that would be helpful if Mr. Helsten's not ready to take the vote. Thank you. Thanks for flagging me. Question before us is to continue with the matter and file the, Mr. Boyd, the terminology.
Petition for leave to appeal.
Petition for leave to appeal.
Supreme Court.
Supreme Court.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Lejess?
Aye.
Mr. Stauffenberg?
Aye.
Mr. Whitten?
No.
Mrs. Bernard?
Aye.
Mr. Marcotte?
Aye.
Mr. James?
Aye.
Mr. McLaren?
Aye.
Mr. Vickery?
Aye.
Mrs. Schmidt?
Aye.
Mr. Nicholas?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Yay.
Mr. Pilecki?
Aye.
Mrs. McBride?
Aye.
Mr. Yates?
Aye.
Mr. Innes?
Aye.
Mr. Whitus? Aye. Mr. Tholen?
Aye.
Mrs. Pope? Mr. Arsenault?
Aye.
Mr. McConnell?
Aye.
Mr. Foster?
Aye. The ayes have it.
All right.
Any other matters before the board today? Mr. Scholl?
Mr. Chairman, we received on our desk this handout, and contrary to a policy that was established some time ago, it has no name, no organization, and subsequently has to be discarded. So I would encourage people to, if you're going to put something like this out, for Pete's sake, put your name and the organization that you represent.
That's a good point. Thank you. Do I have Mr. Hess?
Number 9.
9.
Thank you, Mr. Chairman. In the mailboxes, we had this notice for the flood map. Do we have a time for this afternoon for
Yeah,
that?
it seems to, I think it's an open period of time, 2 to 4.
2 to 4, and I think it's 6
It
to
says
8.
a separate meeting for county and public officials will take place earlier that afternoon. It's open to the public from 6:30 to 8:30.
That's 2 to 4.
2 to 4.
2 to 4 session.
Okay, thank you.
Mrs. Schmidt?
Motion to adjourn.
Thank you, Mr. Chairman. Just real quick, lately, with the stimulus package that may be coming out, may or may not be coming out, one of the things that they talk about is shovel-ready projects. And I probably should have brought this up in old business, but it would be good for us, I think, to have the expansion of the courthouse, or the, we shouldn't call it that, but the more new, the space needs issues with the courthouse, the highway department, and animal control, work on that to make those all shovel-ready projects, just in case some money may trickle down our way, and we can take care of those issues.
Trickle down, please.
Sorry.
Trickle down.
All right, maybe sent our way.
Just one last thing for the handout that was given. If the people that gave us the handout would please document the source or attribute it and put it in our mailboxes, that would be appreciated, just because it's worth reading. Thanks.
Motion to adjourn.
Motion to adjourn by Mr. Washington, a second by Mr. Arsenault. All in favor, say aye. Opposed?